like to welcome you back to our third lecture on the program in a joint initiative between and amongst FGV Direito Rio, FGV Direito São Paulo, and the Chicago University, the Law School of Chicago University, on this program, on this forum in law and economics. Before we start, I would like to remind you all that all the statements made by our professors and guests represent their own opinion and not necessarily the institutional position of FGV. They all also agreed to record these broadcasts to future use in the video channels of FGV and Chicago University. I would like firstly to thank again Maria Lucia, my colleague from FGV Direito São Paulo, and Professor Omri Ben Sahar from Chicago University for making this program possible. This is a first initiative. This is just a teaser. This series of webinars is just a teaser for the forum that we intend to organize presentially every year in São Paulo and in Rio. And today we have the pleasure to have here Professor Adam Chilton from the University of Chicago. And we would like to give word to Professor Omri to introduce him properly and thank you again, Professor Adam, to be here with us, sharing your knowledge. It's an honor to have you here in our program. Thanks, everyone. I hope and I'm really sure that we're going to have another very good afternoon with our speakers. Thank you.
Thank you, Rodrigo, and thank you, Maria Lucia, for joining us and hosting the second week of this exciting month of September, in which the University of Chicago and the FGV schools in Brazil are working together to introduce basic and advanced ideas in law and economics to an international audience. It couldn't be a greater pleasure today to start this second week than to introduce my colleague Adam Chilton, who perhaps more than anyone else on our faculty represents what University of Chicago is about and the spirit of our school. But Adam Chilton has infinite curiosity and is an expert in so many areas, where in each he's doing cutting edge work. He, of course, is widely known and has done a lot of work on comparative law, but he is equally productive in areas like international law, international trade, and labor migration. He's interested in areas like human rights and poverty law. In fact, he has an ongoing, phenomenally interesting project studying the slums in India, where he's already produced a documentary film, and he's working on a book with another colleague in our law school. Professor Chilton is interested also in issues that have to do with the legal profession and how ideology shapes the legal profession, and studies the ideology of law professors, of practitioners, of judges, even of law clerks, to understand how our field is shaped, not just by our knowledge and expertise, but also by our politics. And finally, not finally, but maybe the crown jewel of his current interest, Professor Chilton studies constitutional law, but very different. In a typical Chicago way, he does it in a very different way than the rest of the field. He does not just look at Supreme Court decisions and studies the doctrine, but rather asks a basic question on which he will talk today. Do constitutional rights matter? When they do, when do they matter, and when do they not? It is my pleasure to give the podium to Professor Adam Chilton.
Thank you, Omri. Thank you, Rodriguez, and everyone else here. It's great to be here with you today and to have the opportunity to talk about my research on constitutional rights around the world. I'm going to begin by sharing my slides here, so bear with me while I get this correctly set up. And hopefully you can all see this fine. Now, the research that I'm going to be talking about today is all joint research with my collaborator and friend at the University of Virginia, Mila Versteeg. And we've been working together since we first met at a law and economics workshop dinner at the University of Chicago about 7 years ago now, early in the fall of 2013, on a series of papers that recently culminated in the publication of a book on how constitutional rights matter. Now, let me tell you a little bit about the problem that we're trying to answer in this book and how we're trying to bring law and economics research to study essentially a quintessential public law question. Now, here's the question and the puzzle at the core of what we're after and what we're trying to understand. And it's this. Now, there's 3 trends that are worth noting about constitutional rights around the world that I think encapsulate the fundamental problem of understanding their effect. So here's the first trend, trend 1. The number of rights that are included in countries' constitutions has increased dramatically over the post-war period. So the graph that I'm showing you here first is the average number of rights in countries' constitutions from 1945 till 2015. And what it shows you is that in 1945, the average country in the world had 22 rights in their constitution. Now, by rights, these are individual specific protections that are enumerated within the Constitution, like the right to free speech, the right to freedom of movement, the right to freedom of assembly, the right to form political parties, etc. Now, the average number of rights has essentially doubled since World War II, and it's now roughly 42 rights that's in the average constitution around the world. So on average, countries are enumerating more things that they're protecting in their constitution than ever before. And this is a trend that became particularly pronounced after after 1990 and the collapse of the Soviet Union and the Eastern Bloc. All right, so that's the first trend. We have more rights in our constitutions than before. Here's the second trend. What this graph is showing you is the actual protection of rights around the world. And to do that, it's looking at the same time period using data that's called a human rights score that was developed by a political scientist named Christopher Ferris. Now, this is an aggregate composite indicator that it's slightly complicated, but roughly what it's doing is taking a lot of different indices that measure human rights in different ways and trying to aggregate them to try to get a single picture of how human rights fare around the world. Now, what this is showing is that since 1950 until now, human rights are roughly 1 standard deviation better around the world, and that there's been a big upswing over the 80s, 90s, and 2000s. Now, this, I think, for many of us, comports with our basic lived experience. We see, for instance, there's more women in the workplace, more women in our educational institutions. There's greater respect for same-sex marriage or marriage equality around the world. There's greater freedoms for different political opinions, people of different races, etc. So around the world, we're seeing this sort of gradual march and gradual progress that's being made where rights are being better respected. So at this, trend 1 is that we have more rights enshrined in our Constitution. And trend 2 is that the actual protection of rights, that is de facto rights, has been getting better as well. All right, here's trend 3. Trend 3 is just simply taking those 2 variables and graphing them against each other. Now, on this third graph, on the x-axis is the number of rights in countries' constitutions. And the y-axis is that human rights score, that measure of actual protection of rights that I just mentioned. And what you see is that these things are clearly negatively correlated. That is, countries with more rights in their constitutions actually do a worse job at protecting human rights than countries with fewer rights in their constitutions. Now, by itself, this kind of data doesn't prove anything. There is a huge number of different possible explanations for these patterns and these trends. For instance, it could be the case that newer countries that have been, well, not newer countries, but countries that have written their constitutions more recently, when doing so, might have added more rights to those constitutions. And because these are younger countries with less rich constitutional traditions, less history of independent governance, they may have worse human rights records than countries that have had their independence for a long time, like the United States or Canada or other countries. And even though the human rights in their constitutions might be helping things get better, there could still be a negative trend. That is, we don't expect the newly freed countries in Eastern Europe or in Africa, et cetera, to catch up with countries that have a long history of democratic government overnight. But it at least raises the question that it's not obvious that putting rights into constitutions does much of anything. And in fact, it brings rise to a famous quote from the political philosopher Joseph Raz, that this is a good time for human rights. Now, that's the first part of the quote, which in part perhaps refers to our first trend. But the rest of the quote is not that they are respected anymore in the past. Now, what Raz is getting at is that we talk about human rights. Countries put them in their constitutions, they sign international treaties, but it's not clear that all of that work is doing much of anything. And in fact, it's possible that it takes us all the way back to what the author of America's Constitution, James Madison, said at the time that he wrote the United States Constitution, which is that he worried that including rights in constitutions would be nothing than mere what he called parchment barriers. And by parchment barriers, what he's saying is that you can put rights into constitutions, and we can say in the United States Constitution that we'll respect freedom of speech and freedom of religion and freedom of assembly, but the mere words on the page itself might not do much at all. So even though James Madison wrote the United States Constitution and included a Bill of Rights within that Constitution, there was skepticism about whether or not that rights would do anything. Now, it's easy to find examples of these so-called parchment barriers that can make us skeptical. Here's just one example. So for instance, perhaps the most famous clause of any constitution is this, that Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, the press, the rights of the people to peaceably assemble and to petition the government for redress of grievances. Now, this is the First Amendment of the United States Constitution, and this might just be my own American-centric perspective, thinking that this is famous language. But I do think that, since the founding of the United States Constitution, this kind of language has set the tone for rights in many constitutions. And just one piece of evidence of that is, in addition to the United States Constitution, this similar language is found in other countries. For example, another example of the same language in another constitution is that citizens are guaranteed freedom of speech, of the press, of assembly, demonstration, and association, and citizens are entitled to submit complaints and petitions. All right, so this language that's similar to the First Amendment of the United States Constitution is actually from North Korea's constitution. That is, even in North Korea, they include the same claims to freedom of speech, press, assembly, and demonstration within the constitution that we have in the United States. Now, of course, North Korea is famously repressive, perhaps the most repressive country in the world. And yet they copy and crib the language that's meant to enshrine individual freedoms from the United States Constitution. And this example, although particularly stark, is not the only one. In fact, it's trivially easy to find examples of countries enshrining rights in constitutions that are in direct contradiction with those countries' practices. To give you a few more examples, for instance, in Pakistan, which consistently ranks worst on measures of gender equality around the world, or at close to worst, it says in their constitution that there shall be no discrimination on the basis of sex. In Zimbabwe, that was ranked at the bottom of measures of torture scales during the reign of Mugabe as president there from 1980 until a few years ago. Their constitution specifically said that no person may be subjected to physical or psychological torture, despite engaging in this repeatedly and consistently throughout Mugabe's rule. And then finally, Afghanistan, which currently ranks at the bottom of almost all measures of education and access to education, includes within their constitution that education is the right of all citizens of Afghanistan, which will be offered up to the BA level in the state educational instances free of charge. So again and again, we see examples of countries putting rights into their constitutions that they haven't historically respected and don't seem to take particularly seriously. Now, all of this sets up the question that we're setting out to ask. That is, does having a de jure constitutional right in a constitution improve de facto respects for rights? Now, to be clear, what I'm not interested in asking is simply what's the correlation. That is, what I am not asking is whether or not having a constitutional right is associated with more respect for rights. But when you decide as a country to put something into your constitution and say, we're going to respect the right of education or the right of assembly or the right to freedom of speech, or we're going to prohibit torture, and you write that down in your country's most important legal document, does anything change? Do things get better as a consequence of having that right? So that's the question that we're setting out and trying to answer. Now, across our research on this topic, we've essentially tried to lay out 4 claims for how this works. That is 4 arguments for how constitutional rights are likely to have an effect. And I want to walk through each of those arguments. So the first argument you probably can expect from the last few minutes in the introduction here, which is that rights typically don't do very much. That is, it's trivially easy to find examples like the ones that I just provided, where countries put a right in their constitution and nothing at all changes. Examples where countries will include a right to gender equality, but still oppress women. Examples where countries will include a right to freedom of education within their constitution, but not do anything to fund their schools, or include the right to housing, but still have countless scores of people that are homeless without basic access to housing. Now, these aren't exceptions. These are actually the norm, in that typically it's difficult to find evidence of clear changes as a consequence of adding a right into a constitution. That is to say, there are instances with countries that have good human rights records that add a right to their constitution and continue to do so. For instance, Norway recently revamped their constitution, included more rights protections. And unsurprisingly, Norway is doing a good job at protecting those rights. The issue is they're not really doing anything different than before when they recently revamped their constitution. They were good before and after. Now, on the other hand, you can also find examples, for instance, Australia, where there's limited written rights within the constitution, but yet the country has a relatively strong comparative record on human rights. Although again, no one's perfect on these issues. And other instances where countries will have dozens upon dozens of rights and completely ignore them and not do much of anything. In other words, the basic record is that on average, rights don't do very much to protect people. So that's the first claim. Rights typically don't do much. Claim 2, rights that empower organizations are more likely to be effective. Now, to be clear, what this argument is that when a right specifically says that this organization now has new powers and new authority, those organizations then are able to use those rights in ways that to advance their agenda, to protect their right to exist, and to have more ability to affect the changes that they're looking for. Well, what kind of rights am I talking about here when I say rights that empower organizations? Now, there's many possible examples, but the 3 clearest are the right to form political parties, the right to form unions, and the right to form religious organizations. So take political parties, for instance. When countries say that there's the right to form opposition political parties, that's more likely to be effective than simply saying that countries have a prohibition of torture. And the reason is that that political party is likely to then take the constitutional text, and anytime there's a crackdown that tries to happen against that political party, they'll be able to use the text of the Constitution to try to argue to protect themselves. And so they're able to take the actual fact that they have a right enshrined with the Constitution to do better to protect their values. Now, the second half of this sentence is important as well, which is just because there are rights that power organizations in a constitution doesn't mean that those rights will always be effective. That is, this isn't deterministic, and law is not like physics, which is to say that there are instances of cases where there are strong organizations without constitutional rights, and there are other instances of organizations that are repressed and kept down that do have rights protecting them within their country's constitution. So this isn't a claim that there aren't any examples that can disprove this, but instead the claim that on average, when organizations have rights within their constitutions, those organizations are more likely to be successful. So that's the second claim. On average, organizational rights are more likely to be effective than individual rights. Now, the third claim goes against what a lot of lawyers frequently point to as the mechanisms through which rights have an effect, which is to say that independent courts and democracy don't actually do a huge amount to change the probability that rights will be affected. Why is that? Now, frequently what people think is that, sure, if it's North Korea and you have the right to freedom of speech, they're not going to respect it. After all, the government's autocratic, oppressive, totalitarian, and they're going to crack down on their citizens. But if you were in a country, so the thinking goes, where you have courts that you can go to that are independent, you can make a claim and say, look, there's something wrong that's going on within the country. Courts, please fix this for us. Try to respect these rights. Now, lawyers have frequently pointed to these mechanisms, independent courts, the presence of democracy, of trying to highlight ways that rights can have a difference, the mechanisms through which they work. But our research has suggested that these two mechanisms don't matter that much. There are plenty of instances of countries that think they have independent courts, where those courts then frequently give way in the face of a strongman, an autocrat, a dictator, incredibly quickly once that person or that political party is determined to press down on power. But at the same time, there's instances of organizations that are able to push back even when the courts aren't receptive to their arguments. The reason is the distinctive feature of organizations is that they have the ability to organize citizens to apply political pressure. And they're able to do so in many cases with or without courts willing to help them. And with or without elections, if it's the case that they can effectively organize. So the good news here is that even in countries that are autocratic or that have weak courts, when there's independent organizations that have constitutional protections, those groups are often able, on average, to protect their rights. Now, this brings us to our fourth claim that is less good news again, which is that when governments are dedicated to repression, it's likely that they'll eventually succeed. Now, here the way to think about this is that the analogy that's historically been used by legal scholars to describe rights is like tying a government to the mast from Ulysses, where people say that by enshrining a right into the Constitution, you're tying yourself to the mast and committing yourself as a government that in the future, even if it would be efficient to torture citizens, to deny the right to freedom of press, to oppress minority religious groups, to deny the rights of women or sexual minorities, that by putting these rights in the Constitution, you've tied yourself into the mast so future political wills can't tempt you away into repression. That's the analogy that's historically been used to describe constitutional rights. But I think that's the wrong analogy, because tying yourself to the mast makes it seem like you can pre-commit yourself in a way that you can governments can prevent themselves from being tempted to repress. That's not really the way that it works, though. That is, when there's governments that are dedicated to repression, if that is their goal, if given enough time, even if there's organizations that line up to try to stop them, it's often the case that they'll eventually succeed. That is, the rights and the organizations that are lined up against their repressive government are only a speed bump in the path to repression. And if the government is determined to stay on that path and doesn't change course for some reason because of new elections, new political leaders, change in international pressures, etc., then it'll be the case that the repression will likely happen. All right. So that's the four basic claims that we've been advancing across our research. Rights typically don't do much. Rights that empower organizations are more likely to be effective. Whether or not there's independent courts or democracy doesn't matter, and that governments dedicated to repression eventually succeed. So that's the claims, but what's the theory for why these things are true? How can we tie these four claims together into one simple theory that can explain what's going on? Now, here's a way to think about it that's trying to distill down a lot of pages of arguments in a whole book into a few slides, but here's a way to maybe think about the way that this works, which is, imagine that there's a timeline that exists, and at time zero, a country adopts a constitutional right. Now, the country can adopt this constitutional right for a large number of different reasons. For instance, a country may adopt a constitutional right because there's an existing interest group within the country that is agitating to add that right to their constitution, either as an amendment or during a process of constitutional drafting. So in this case, it's that there's already a strong interested domestic group and they're pushing for this particular kind of change. Now, another way this can happen is that there's international templates of rights that exist, standard rights that people look to that come from the Universal Declaration of Human Rights, from international treaties, from countries that have been seen as being leaders in the development of constitutional rights, and that countries might just copy wholesale rights from those constitutions, even if those rights don't necessarily have strong domestic support within the country itself. Or it can just be a historical accident. That is, there's instances within the historical record where it's not exactly clear why a country added one right and not the other. It was added into a draft by someone that was drafting it by mistake, by accident, by subterfuge, by secret, etc. The point being, rights can end up in a constitution for any number of reasons. Now, after a right is added to a constitution, you can then think of a honeymoon phase where that right is not yet being cracked down upon. Now, during that honeymoon phase, if the right that is being enshrined with the Constitution is about setting up an organization, it's possible that people will take the government at their word and actually set up an organization. For instance, imagine a new constitution sets up a right to form political parties. When that takes place and the government has put this into their constitution, you can imagine different social and political entrepreneurs taking the initiative to go out and in their constitution try to, not in their constitution, they go out and try to actually start a political party, recruit members, get donors, set up a corporate structure, set up bank accounts, legally incorporate, get your name on ballots, take all of the steps to become a full-fledged organization and a full-fledged political party. And the fact that the right was in a constitution might increase the probability that these political entrepreneurs would actually set up a political party. In part because that they might think, because this right is in the constitution, the government is more serious about letting us set up this political party. Or perhaps because they think if the only reason the right is in the constitution is a historical accident or a mistake and no one really cared. But if the government ever does want to crack down on us, the fact that we have this right within the Constitution will make it easier for us to push back. The point being that whatever reason the right was initially adopted, during the honeymoon period, organizations may form, and the fact that the right was in the Constitution increases the probability that you're going to form the organization and grow it, either because you think there's a credible signal that the government won't crack down, or because you believe that if a crackdown does happen, that you'll be stronger because of the Constitution. Now, in some cases, a crackdown then never comes, and you've formed your political party or your religious group or your union, and you just go about operating as you normally would, and you've organized now with this constitutional right. But unfortunately, in other cases, a crackdown does come. For some reason, the existing government, the political powers that be, decide that they no longer want to respect this right that they've enshrined with the Constitution and decide that they're going to try to stop opposition political parties or religious groups or unions. Now, when the crackdown comes, as I previously mentioned, the fact that the right was in the Constitution is actually useful. And because the right was in the Constitution, those groups are more likely to survive and more likely to protect their interests. Now, because that's true, it actually becomes the case that the crackdown's less likely to even occur in the first place, because in expectation, the government knows that if they try to crack down, there'll be a group that pushes back. Now, this isn't always going to be true, this basic oversimplified pattern. For instance, there's some instances, as I mentioned, where the crackdown never comes. And unfortunately, there's other instances where we never even have a honeymoon period at all. That is, a country will adopt a new constitution promising rights to new political parties, but never let them get off the ground. So we can see other patterns that exist, but on average, for the reasons that I've described, the organizations are more likely to be successful if they have a right in the Constitution. Now, it's worth noting, however, that this isn't just a theory claiming that organizations are good at pushing back against the government. the theory is also arguing that the existence of the right itself, the words on the Constitution, the written words that protect political parties and unions and religious groups themselves are helpful, because the existence of those rights in the Constitution makes it easier for the organization to fight back in a crackdown. Now, what I mean here is that you can imagine a hypothetical where you have two countries that are the same in every way, that both have a strong union movement and strong labor unions, and the government decides to crack down. But in one country, that labor union can point to a constitutional right, and in the other country, the labor union can't. Now, why is this? Why is the Constitution helpful? Specifically, the fact that you can point to it. The reason is that it solves two problems. So the first is the so-called coordination problem. Now, what the coordination problem is that we need to agree when a government action actually constitutes a violation. And by we here, I'm referring to the public, the citizens, the people of that country need to agree. Now, in some cases, this is extremely obvious that a government's violating the Constitution. For instance, if the Constitution says that a president is limited to 2 terms as president, and they just decide to stay for a 3rd term, in these kinds of cases, it might be an open and shut case. But from our own country's political experiences, it's easy to think of instances where the government will take actions that many of us believe are constitutional violations and that have violated rights, where there isn't agreement among all of the citizens. Some citizens will say, this has gone too far, this now violates the Constitution, and other citizens will say, you're mistaken, this is perfectly okay. Now, to try to push back against a government crackdown, though, you need to actually get citizens in large numbers to agree that a violation is taking place. The existence of a right and an organization together, when you have those two things, make it easier to solve this coordination problem. And what I mean by this is that, for instance, if you have a right to political parties within your constitution, and the government is cracking down on the existence of opposition political parties, and they can point to the Constitution and say, Article X, Section 3 protects us. They not only have clear arguments to make their case there's a violation because it's written down, but they're able to convince their membership. And their membership are able to convince other people, other members of civil society. So the existence of the organization can convince people when there's a written constitution about what constitutes a government human rights violation. So the existence of the organization plus the right together make it possible to solve this coordination problem. Now, the other problem that the existence of the right and the Constitution taken together are able to solve is a collective action problem. Now here, even if we all agree that our government is violating our rights in some way, you frequently need to take actions to punish the government for those violations. Now, those actions might be as simple as all turning up to vote if your country is at least partially democratic, but it might be a mass protest in the streets and actually going out into the streets to protest against your government. Now, protests can happen spontaneously. Protests can happen through social networking, through minimal organization, etc. But in many cases, there's actually organizations that are doing the groundwork to make these protests possible. And organizations are able to overcome the collective action problem that exists before protests. Because it's perfectly natural for any one of us to think before a protest, if I go out into the street and I'm the only person that turns up for this protest, it'll be easy to arrest me. The government will be able to see my face, harass me, my friends, my family, and punish me for speaking out in this way. But if I know that there's an organization that's a popular organization with a lot of resources and many members and a history of organizing well, then I might think, you know, they're telling me that they're going to turn out lots of people. And if I turn out as one of these people, I won't be alone. And so the collective action problem of finding ways to organize, to protest, to push back, to do things to argue against the government are also better solved by governments. So the existence of organizations that are protected by the Constitution help overcome both of the main problems that have been identified is stopping governments from violating rights. Now, that's the basic theory for how this works. How does this actually play out? Well, here's just some simple data, and I'm going to show you a lot of data today. We're going to go into more examples on torture prohibitions. So this is showing you in the 5 years and before and the 5 years after countries adopt torture prohibitions in their constitution and a measure of their human rights repression. And what it's showing you is that on average, nothing changes at all. And in part, what's going on here, at least our theory suggests what's going on, our theory's interpretation of this data, is that in the years after some country adds a torture prohibition to their constitution, there aren't organizations and political entrepreneurs that are chomping at the bit to form the new anti-torture coalition. There might be a small one, there might be some people doing this, but it's unlikely to be a big mass member-driven organization that has widespread support across a huge percent of the population. That is, although some small human rights form, these are typically small operations with a handful of core members with limited funding. And as a result, when later the government decides to actually torture, this honeymoon period isn't really taken advantage of. In other words, this right is added to the Constitution, no one takes advantage of a honeymoon, and if a crackdown comes, nothing really changes. Now, contrast this to the right to political parties. This is the 5 years before and after countries adopt the right to political parties. And this is 3 different dependent variables that measure, that have been used to measure the respect for the rights to political parties within countries. With these 3 different measures, you see the exact same pattern, which is countries add this right to their constitution, and in year 0, immediately you see a jump in the respect for those rights, and you see an increase in the rights of the political parties on average. Now, this is also intuitive in that countries like North Korea or Zimbabwe under Mugabe, or take your example of whatever you think in a repressive state is that doesn't care about the rights of their citizens. Those countries will frequently not hesitate to sign a human rights treaty or not hesitate to add an individual right to their constitution. But they will fight tooth and nail to keep opposition political parties from forming and getting strong, and they will keep that language out of their constitution. So these countries' constitutions will say the right to freedom of speech will not be abridged, but it will never mention forming oppositional political parties. The reason is, as simple as it is, they believe in something like our theory. Those dictators, those autocrats think you can promise people freedom of speech and it won't slow me down if later I want to repress someone. But if I give an opening to form oppositional political parties, I later might pay a cost for doing this. Now, again, this doesn't mean you can never crack down or governments never will. It's just a little more difficult. And so this is the basic pattern that we see in the data when you compare respect for individual rights versus organizational rights. So what we're making is a claim that you'll see differences in the patterns at which rights are respected and denigrated over time, depending on the type of rights. Now, it's not just the raw data that looks this way in these examples that I'm providing. It's easy to find examples from the historical record that say the same thing. So to give you just one example that we use as a case study in our book is the change in the respect for rights in Putin's Russia over the last, since the year 2000, so over the last 20 years. And this is abridging a huge amount of detail, but the basic story goes something like this. In 1991, we have the fall of the Soviet Union, and immediately see a groundswell in new rights and new freedoms that exist within the country. Rights to form independent news stations that are critical of the government of the first time. Huge numbers of new religious groups either begin to operate within Russia or come out of the shadows, and new religious freedom flourishes after decades of repression under Soviet rule. You see a decrease in punishment of political opposition leaders, an increase in rights across a range of different measures that exist in Russia during this period. Now, these new rights become enshrined in Russia's constitution in 1993, which includes a Western-style Bill of Rights that protects many of the rights that I mentioned. Now, in the year 2000, Vladimir Putin runs for president in Russia, and as part of running for president, he issues a thing called the Millennium Message for the year 2000, where he says that the Russian people need to get back to what's authentically Russian, values of nationalism and patriotism, and to move away the protection of some of these rights. Now, beyond this, though, Putin highlights the Constitution and the rule of law as a primary message that he thinks should be respected going forward. So at the same time that Putin is saying that some of these rights and some of these values aren't Russian, he's saying we need to get back to the Constitution. Now, after Putin is elected president, what you begin to see is an erosion of these rights that existed in the 1990s. But the way that this erosion occurs is not equal for all rights. So to just put this in stark contrast and fit it into our theory, you compare the right to freedom of expression to the right to freedom of religion. Now, within the right to freedom of expression, what you see, and a pattern that occurred, is that Putin begins to put opposition news stations and critical news stations and newspapers out of power. New laws are passed that criminally prohibit libel, that prohibit extremist speech. People are targeted for their criticism of the government. Opposition political leaders are targeted when they speak out against Putin as well. And freedom of speech and the sphere of criticism within the public domain is increased, and it's increased relatively quickly after Putin takes over. However, you see a different pattern with the freedom of religion. As I mentioned, after 1991, you see a flourishing of religious groups within the country. This both includes the Russian Orthodox Church taking on new life after decades of limited ability to get their message out under the Soviet Union, but also new religious groups coming into the country, different Christian sects that are coming into the country and operating, minority religious groups that are forming, new Christian churches across the country, a variety of different denominations. Now, a series of laws, or the Russian government tries to pass a series of laws to try to crack down on these religions. But the religious groups organize against them. And not only are they able to get all of their membership upset at the idea that religion would be cracked down upon, the religious groups are able to connect with outside religious groups from outside Russia in places like the United States or in Western Europe. And those religious groups are able to bring in resources and help and political pressure that the organization is able to bring to bear on the Russian government to prevent this crackdown from taking place. The results that you see is that there's shrinking space for freedom of speech. At the same time, the religious respect for religion is not being decreased as quickly. Now, I said that we had 4 claims within our book. Rights typically don't do much. Organizational rights are more effective than others. It doesn't matter if it's courts enforcing this, but the final claim is that sooner or later, if the government is set on repression, that repression will happen. And that's what we've been seeing in Russia as well, which is that the initial pattern was that there was greater continued respect for religious freedom than the right to freedom of expression. But over time, that's eroded as well as the government maintained its campaign of putting pressure on the religions. So this is the kind of pattern that we see, that the rights to organize religious groups were a speed bump, but they didn't tie the Russian government to the mast. And over time, eventually, this pattern, as a consequence, began to change. All right. So within our theory, then, it's important to say that we think there's some collective rights and then some individual rights, and these will be respected differently. So as examples, pure organizational rights include the right to form political parties and the right to unionize. Quasi-organizational rights is like the right to freedom of religion, where it's about partially setting up a religion, but also just the right to worship. And then within individual rights, you have civil and political rights, like the prohibition of torture, freedom of expression, freedom of movement, and socioeconomic rights, like the right to education, the right to healthcare, the right to social security, the right to housing, etc. Okay, so now we've got a big problem, that is, do constitutional rights make a difference? Do they do anything? And a theory that I've outlined of 4 arguments about how they might make a difference. Here's the challenge and the difficulty about actually making progress on testing that theory. The challenge is this. The adoption of constitutional rights is typically a deeply endogenous process. What do I mean by that? The rights that are included within countries' constitutions are often there because, in part, something to do with the way that the country thinks about respecting those rights. So there's a relationship, to put this in empirical terms or in economic terms, between our independent variable, which is the existence of a constitutional right, and our dependent variable, which is the respect for those rights. The problem is that these endogenous processes make causal inference near impossible. So to put this in terms that might make sense, imagine we want to know whether or not a particular kind of diet helps people lose weight. That is, does adopting this new diet craze make people lose weight? But we have this problem that if we don't use random assignment and we don't conduct a scientific study where we randomly assign people to participate in the diets, and we're only able to observe people that adopt the diet versus people that don't, even if we can see in the data the people that adopt the diet lose weight, it doesn't necessarily tell us that the diet did anything at all. And the reason is what's called selection bias, which is the people that choose to adopt this diet might be fundamentally different than the people that don't. They might be the kind of people that want to lose weight and that are motivated to do so. And as a result, they adopt this diet and lose weight, but it could be nothing to do with each other. And instead, just because they're health conscious, or that they're trying a variety of different strategies, or that they're also exercising. So we don't know. Now, this basic problem of selection bias makes using data to study processes with observational data where we don't have random experimental variation extremely difficult. Now, it's extremely difficult in the best of circumstances, but when making comparative claims about a deeply endogenous process like the adoption of constitutional rights, like the one that we're talking about today, this is even more difficult. So for instance, Holger Spalman, who's a friend and professor at Harvard Law School, actually says that given how hard it is to study these causal claims empirically, that efforts to engage using statistical methods are likely to do more harm than good in comparative settings. That is, when we try to study questions like, do constitutional rights matter, the position that Spalman takes is that the problems are so difficult that they do more harm than good to even try. So we shouldn't be trying to figure out the answer to this question with statistics or with data. Jonathan Click, who's a professor at Penn Law School, says that the comparisons across countries are close to worthless and having no confidence in the causality. That is, we can't know anything when we try to answer these questions with statistics. So these are the kinds of attitudes that exist. So that's the challenge that we're facing, is that we've got a big question that exists. Do constitutional rights make a difference? We've got arguments and we've got some evidence about how we think that this works. But people have pointed out that the challenges are so deep to actually study this that it might be not worth trying. Now, the view that I take, though, is one that MIT political scientist Richard Nielsen has advanced, which is to point out that many of the questions that we're interested in about politics, about international affairs, about human rights, that the most interesting questions are always impossible to answer. And that as a result, as researchers, we're left with the choice of chasing small questions where we can nail it down, or big questions where we have to just do our best. And this isn't just constitutional rights, that when we're interested in is public law, nearly all questions are hard to answer. And the reason is that public law is law where our governments, whether or not it's constitutional rights or international treaties or statutory obligations, is setting policies that are meant to be universally applicable in non-random ways. And given that, in public law, the big questions always have these properties where they're hard to answer. And if we decide that we're scared of the causal inference problem, we won't learn anything about the effect of public law. So what do we do then, given that we think this question is important? We have a theory about the answer to this question, but we recognize that there's deep challenges to actually answering it. Our approach is this. It's to use what's sometimes called multi-methods research or mixed methods research, an MMR approach, where what we're trying to do is bring a range of different methods together to answer the same question. That is, instead of thinking that there will be one perfect method that can nail the answer to this question, thinking that by bringing together different methods that are all different ways of climbing the same mountains, we can have more confidence in the methods and the answers than any one approach alone. So through our research, we've taken a few different steps that I'll mention. So the first is to try to collect improved data on constitutions around the world. We've done first complete coding of constitutional rights based on written documents. I'll talk more about this in a second. We've done expert surveys of experts around the world on constitutional rights within their countries to collect new data. Additionally, we've sought out and looked for natural experiments in instances where we have better purchase on this causal question because some fluke of history has created circumstances that make causal inference possible. Next, we do use statistics, but when doing so, we try to use methods and for our large N analysis that make the counterfactuals that we're studying more explicit, more transparent, and more clear than using black box statistical methods. And then we additionally use survey experiments where we go to different countries around the world and try to conduct surveys to try to understand the relationship between constitutional rights, public opinion, public attitudes, and support for public policy changes. And then finally, we use case studies where back when we were allowed to travel, we traveled to countries around the world to try to document some of these mechanisms that I've been talking about. All right, so these are the sort of 5 different approaches that we've taken: improved data, natural experiments, large N analysis, survey experiments, and case studies to all answer the same question. So I want to tell you a little bit about each of these 5 different methods and what we've been able to document about the effect of constitutional rights and constitutional rights around the world. So first, improved data. Now, our data collection on documenting constitutional rights is, for the most part, you can think of it as 2 separate projects. So one part of that project, and for this I should be clear that Mila really gets all of the credit, has been to document the constitutional rights that exist within so-called large C constitutions, or that is formally written constitutions. So to do that, for all of the 194 widely recognized countries in the world, we went back in history and found their written constitution and then traced every amendment to that constitution. And within that, coded specifically in each year for each country what rights existed within their constitution based on their formal written documents. So for instance, I already used some of this data at the start of the presentation, but we're able to look at the increase in constitutional rights over time. Now, within this, we've documented 87 primary rights that exist within constitutions, but within that, there's many different versions of these rights. So for instance, if you take the right to gender equality, some countries might have the right to gender equality in their constitution, but other countries might have the rights for pregnant mothers or rights to working mothers, et cetera. So different variations on gender equality within their constitution. But at some aggregate level, there's the concept of gender equality, which is one of the 87 rights that we've documented, even though there's many more sub-rights. Now, from that, we can look at then at the rights in different countries and break them out by how many rights countries have. For instance, you can see countries like the United States or Australia or Canada have relatively few rights. They're in the bottom quartile, whereas Brazil is in the top quartile for having the most rights within its country. And then specifically, once we have these broad rights, we're then able to take key rights and look at their trends over time. For instance, in our recent book, we focused on 8 rights, although in various research projects, I think we've studied 12 or 15 different rights in different papers now, including these rights, unionization, political parties, et cetera, that I've mentioned, but also the right to gender equality, the right to associations, the right to housing, the right to Social Security, and other rights that we've also studied. Now, in addition to this large C data on constitutional rights, it's important to recognize that there's many rights that become constitutional within a country that are actually not in a country's written constitution. These are sometimes called small c rights, rights that have become constitutional over time, that have been given that status, even if it wasn't initially written down. The difficulty as a researcher, though, is once you know that there are small c rights, is figuring out a systematic way to document them, because I can't go ask the president of the Supreme Court in every country exactly which rights they've recognized. And I can't just get the written documents the way I can track down, as I showed you before, the physical copies of every constitution that's been written in the world. So what to do about the existence of small c rights? Now, our answer to this problem has been to conduct a long-running global expert survey of constitutional law professors and experts from around the world about the small c rights in their own countries. To date, we've completed expert surveys with experts from 220 countries, from 123 countries, where we've gotten information on the small c rights in those countries that might not be in the large C written constitution. Now, within that, we've tried to document from different experts, both generally and for specific rights, whether or not the source of rights within their country is exclusively the large C constitution, primarily the large C constitution, or the small c constitution, et cetera, or a mix of the two. To give you one piece of data on this, The majority of countries around the world, their experts claim, are a mixed regime, where they include both small c constitutional rights and large c constitutional rights. That is, there's both things in a written formal document that's a constitutional right, but also things that are from other sources. So for instance, both the United States and Brazil, experts claim, are a mixed regime of constitutional rights, whereas Australia, New Zealand, the UK are small c regimes where the source is small c rights. But then there's other countries, for instance, in much of Africa or Central Asia or Eastern Europe, where it's exclusively large c as the source of rights. A few other things I'll note on this is that if you look at this is constitutions dating back to the American Constitution, then the drafting of the American Constitution in 1790, and whether or not those countries' constitutions are small c and mixed c regimes or large c regimes. What you see is essentially all of the old constitutions, the historical constitutions, are all mixed regimes. And it's only the newer constitutions where you see these exclusively large c regimes, which could be either something different about these countries, or it could suggest that over time, countries might start as large c and move to small c or mixed regimes as other sources take on prominence. Now, what sources can be sources of so-called small c constitutional rights? Well, the answers from different countries have included judicial interpretations, international treaties, conventions, quasi-constitutional laws like superstatutes, or common law precedents even. And different countries have adopted different combinations of these sources as the basis of their small c rights. One final note on this is that, interestingly, that this isn't just a civil law versus common law phenomenon. And what this is showing you is the percent of countries that are civil law countries and the percent of countries that are common law countries that look at each of these different sources that I just showed you as sources of small c constitutional rights in your country. And what it shows you is that civil law countries are more likely to care about treaties as sources of constitutional rights. That's the second line down. And they are less likely to care about common law precedents. That's the second to last line down. But for judicial interpretations, conventions, quasi-constitutional laws, and the total number of sources on average, they behave the same here. So even civil law countries add small c constitutional rights to their countries at one given time. All right, so that's how we get data on constitutional rights around the world and the different steps we've taken to secure information on what rights countries have in their constitutions. Now we can move on to thinking about how we can comprehensively answer the question rigorously and with data about whether or not adding those rights to constitutions actually translates into improved respect for rights. For the reasons I mentioned before, the so-called challenge is this selection bias, that is the deeply endogenous relationship between adding rights to constitutions and actual performance of those countries' human rights records. One way to get around this problem of this deeply endogenous relationship is to find instances of natural experiments where the rights that are included within a country's constitutions actually don't bear specific relationships to the factors within those countries themselves. Natural experiments thus help account for selection bias and make it possible to study these trends. So in our book, for instance, one of the natural experiments we leverage is the so-called Lancaster House constitutions. Now, the Lancaster House constitutions, the background is this, which is that the British Empire has, in 1959, countries around the world that are British colonies that are going through the process to become independent. And the British government is assisting, coercing, cajoling, depending on how you think about it, those countries through the process of drafting their constitution and helping those countries draft new independence constitutions. Now, initially, the first countries pre-1960 that gain independence and have new constitutions do not have Bill of Rights within those constitutions. So what we have is a set of countries that has a new constitution, but they do not have constitutional rights. Now, there's a change in the views of the Foreign Office within the UK, where there's a decision to add rights to their constitutions starting in 1960, and going forward, the countries have a Bill of Rights within their countries. Now, the decision to switch to including a Bill of Rights has nothing to do with the specific countries. That is, it wasn't that the Foreign Office was saying, ah, yes, Ghana needs a Bill of Rights, but Nigeria doesn't, because of some historical fact about Ghana or Nigeria. It was just a shift in policy that was exogenous to these individual countries. The consequences then, it breaks the selection bias problem at least a little, although for reasons I can claim, it's not a perfect natural experiment, but at least gives us some purchase on this problem. So what do we find? So here's the human rights record, that is actual respect for rights, in that on average for the countries that ended up with a Bill of Rights in their constitution because of this change in the Foreign Office. What you see here is that over time, their human rights records have gradually improved slowly. This is like the trend I started the talk with, saying that human rights has gotten better on average over time around the world. Now, here's the trend for countries with no Bill of Rights. These countries have followed almost the exact same pattern. Now, what you'll note is that they start at a lower place for human rights, but these countries got independence earlier and in many cases had different initial human rights records. These are the places that were agitating for change the most. And so they started at a lower baseline, but the trend has been near identical. Now, there's fewer countries that are Lancaster House countries without a Bill of Rights, and so this trend is a little rockier, but the same basic pattern exists for both countries. In other words, if you were to just look at this one natural experiment, it's difficult to say that having a Bill of Rights versus not having a Bill of Rights really meaningfully changes the trajectory of countries' human rights performances. In other words, this is consistent with the Parchment area barrier idea we started with. Now, second natural experiment. Another natural experiment comes from Japan. Now, this is the story of B.T. Sirota, who was an American woman who partially grew up in Japan, that was tasked with the task of drafting, in part, Japan's post-war constitution at the end of World War II. And because she was in a unique position where she both spoke English and Japanese, was given a huge amount of power by the United States government when they're drafting Japan's constitution. And as the story goes, that she herself included gender equality into the Japanese constitution without input from other sources, or with at least limited input. So this is seen as a bit of a historical accident where there's one person, independent of a country's history, preferences, interest groups, etc., that puts a right into a constitution. Now, notably, Japan's constitution has not been amended a single time since its post-war constitution. So the same right that B.T. Sirota was able to include in gender equality in Japan's constitution is the same right that exists to this day without change. So what actually happened? Well, here's the what happened for gender equality in Japan from 1945 until 2003, using a measure that's based on the World Development Indicators called the Historical Gender Equality Index. Now, what this measure does is essentially combines a number of different measures like life expectancy, participation in the workforce, infant mortality, and averages them. So a score of 100 would mean that both men and women do equally well within the country. But a score of 50 would mean that women do half as well as men. And what you see is starting in 1960, women in Japan do about 60% as well as men on these various indices. And over time, that's grown to a score of roughly 70. So from 1945, with the adoption of this constitution until 2005, things have gotten better. Now, here's all countries on average during that same time period. Again, since there's many countries, the line is going to be smoother and less prone to changes that exist when you're looking at one data point versus averaging many data points. But the same basic starting point and ending point on average for all countries exists within this example. And on top of that, if you take countries without a right to gender equality, for instance, the United States, which famously does not have an equal rights amendment in its constitution, you've seen the exact same basic pattern. In other words, Japan got better on its right to gender equality, but it ended in roughly the same place as other countries. So we have yet another natural experiment where it's not clear that adding this right to Japan's constitution meaningfully changed the trajectory of gender equality rights within Japan. Now, natural experiments are nice because they have this property of accounting for selection bias. That is, we have a reason to think that the right is roughly exogenous, and it's not a deeply endogenous process that created both the right and the protection of the right, which would bias our empirical analysis. The downside of these natural experiments is their generalizability, which is to say, there might be unique reasons that the experience of the Lancaster House countries or of Japan in gender equality are not representative of all countries that either are given a Bill of Rights or given the right to gender equality. The consequence is that we can't know from these examples what the more generalized example is. So they account for one statistical problem, that is selection bias, but they come at the cost of generalizability. As a result, in addition to using natural experiments, we do just use large N statistical analysis. That is, we use statistics, regressions, and other empirical methods to try to answer the question about whether or not countries do better after they add a right to their constitution. However, notably, when we do it, what we've tried to do is consistently do this in a way that's as transparent as possible. And by doing so, we use 4 comparisons that gradually build upon each other. That is, first, we simply look at countries with and without the right to try to understand the average level of respect for that right in countries with and without this right over time. After that, we move on to looking before and after the adoption of right. The advantage of doing this is that we can at least say within a country whether or not there's a change at the time of the right's adoption. Now, a drawback of doing the within country analysis is that it's possible that a right might initially do nothing, but given enough time might begin to have an effect. It's tricky though, empirically, because if you have to wait a long enough time for a right to have an effect, it's unclear whether or not it's the Constitution or the adoption of the right that's making a difference, or some other unrelated trend. So we start with our second comparison, just looking before and after the adoption of the right. Now, third, from here we move on and use what's called a stacked event study, where we take all of the instances of countries that adopted a given right, stack them together into one analysis, and then compare them to a control group where from the same time period of countries that did not adopt the constitutional right into their constitution during this time. Then finally, we take these stacked event sample and we estimate regressions where we include a variety of fixed effects, controlled variables, account for standard errors, etc. So we move on into moving it into a regression framework from here. So what do we find? So I'm going to go through 8 different rights just very quickly to show you the basic patterns that exist in the data. First, here's the first we'll go through the individual rights, starting with the prohibition on torture. Roughly what we find through these 4 comparisons is first in the top left, that actually countries without a constitutional torture prohibition have historically done slightly better than countries with the constitutional right. Second comparison shows us that before and after countries add this right to their constitution, nothing seems to change. Third, we use the stacked event study where we add in a control group of countries that made no change during the same period. And we see that the pattern that's followed between these countries is roughly the same. Finally, we move on to a regression, and this is plotting a regression coefficient for regression that accounts for a number of things, but that roughly shows you that the coefficient has no effect and crosses 0 within its confidence intervals, suggesting that there's no positive impact of adding the prohibition of torture in the Constitution, respect for torture. Here's the same pattern for freedom of speech, where there's maybe a little bit of evidence from comparison 3 that the freedom of speech is doing something, but we can't find anything from the regression analysis suggesting that freedom of speech improves freedom of expression. Another individual right, the freedom of movement, the same story. Things are flat before and after. The regressions are never statistically significant for the right to movement's impact on respect for movement. For right to education, here we're looking at educational spending before and after adopting a constitutional right to education. The trends again are flat. The regressions are not statistically significant. Next, fifth, here's the right to healthcare. What you can see with the right to healthcare, we use healthcare spending as our dependent variable. And there is a gradual increase in healthcare spending over time, in government healthcare spending specifically. However, these trends are pretty flat before and after, and the regression results are imprecisely estimated and close to 0, suggesting there's not a statistically significant change when you actually adopt the right. Now from here, moving to the organizational rights, we see a different clear pattern. which is to say, for instance, take the freedom of religion. Countries in the years after they adopt the freedom of religion sort of clearly do better than they did previously to adopting the freedom of religion. Regressions find a statistically significant and substantively large effect from the fourth comparison. For the right to unionize, you see the same change where there's actually a before and after change from our stacked event study and our before and after comparisons. And the regressions produce statistically significant results where the confidence intervals don't cross zero. And then again, the same pattern from political parties. That is, things get better in political parties after adopting these rights, and the regressions that we estimate are statistically significant and don't cross zero. So our large N data is now consistent with our overall theory, where we don't find effects for individual rights, but we do sort of find consistent patterns for organizational rights that show up in the regressions. Now, I'll just, before ending here and moving on to taking a few questions, briefly mention survey experiments. So we've got an argument that individual rights shouldn't do very much and that organizational rights should. And we have natural experiments and large N data that's consistent with that pattern. But the question is, why don't individual rights do very much? And we've tried to test this experimentally around the world by conducting public opinion surveys on questions where governments have rights that are inconsistent with their constitutional obligations, and tried to see if information on the Constitution changes people's support for that right, that policy. So as one example, we conducted a survey in person through interviews of a nationally representative sample of people across Turkey, shortly after Turkey instituted a ban on the website Wikipedia. And in this survey experiment, we went around and asked people about the ban of Wikipedia within the country. And some people were randomly told about the constitutional free speech protections and the constitutional protection of expression that should theoretically protect Wikipedia. And we saw whether or not people that were told about the constitutional rights were more likely to support allowing Wikipedia to continue to be accessed within Turkey. Here's the specific text of the vignette that we included about Turkey's banning of Wikipedia within the country. Like I said, people were given different treatments, different information about the legality of this ban. And then we asked people, do you support banning Turkipedia or support blocking Wikipedia? And what critically that we see here is that the percent of respondents that support this decision is not statistically different across these different treatment groups that are given different information about the legality. In other words, information on the legality of blocking Wikipedia doesn't change support for doing so. We see when we asked other questions across different treatment groups about whether or not people would protest blocking Wikipedia, they would vote differently. We see the same patterns where all treatment groups respond the same. We've done other surveys on the topic in the United States on torture, on Japan, on women's rights. And additionally, we did 6 countries on constitutional rights and restrictions that have taken place since the start of the COVID pandemic. And we found similar information across 6 countries when people were or were not given information on their country's constitution, on their support for various policies that may violate those constitutions. As I mentioned, out of time here, so I won't talk more, but we've done traveled to many countries to do different case studies where we've tried to look at the inclusion of constitutional rights within those countries to understand their effect on free speech, unionization, et cetera. We go to countries, we talk to judges, experts, et cetera, to try to find out the ways in which rights make a difference. Now, across all of these different methods, across now multiple different research papers that we've conducted, and throughout the book that I've been talking about primarily, we see a consistent pattern that on average, constitutional rights to protect individual rights seem to do very little to actually change rights practices. But when it's organizations that are protected, they actually seem to, again, on average, make something of a difference. All right, I'll stop there and move on to taking questions. I'll just note briefly that we just launched a new website, Mila Verstig and I, that's hopefully easy to remember. That's constitutions.org. where on this website, we have access to a range of different papers that I've been talking about today, as well as a lot of different data from our project that anyone that's interested can download and use for their own research. All right, thank you.
Well, thank you, Professor Adam, for your enriching explanation, very interesting data and analysis. I think we still have 15 minutes we already have some questions from the audience. I would like to remember that all the audience that is watching us through YouTube, there is a link that you can send us your questions through Slido, and I'm pretty sure that Professor will be happy to answer all of them if we have time. So I would like to once again thank you very much, Professor Adam, for the lecture. And Thais, if you could please read us the first questions that we have, and we move on. Thank you.
Hello, everyone. Hi, Professor. So our first question is an anonymous question. Someone asks, if rights are more likely to be effective when they empower organizations, according to claim 2 that you mentioned in the first part of the class, how do you perceive the role of government funding political campaigns or civil human rights organizations?
Right, good question. So, so I take this, how do I think about governments who are both the body that typically can violate human rights or has the most power to do so, taking part in funding civil society organizations. The thing that I would say is that in some cases, it's possible that the government can provide funding in ways that creates truly independent organizations, and that those independent organizations then can push back against the government in time of crackdowns. And there are examples from around the world where there'll be subsidization of civil society organizations, human rights organizations, et cetera, where they are able to push back against their own government. Unfortunately, however, when countries are reliant on their government for funding, it's frequently the case that they become less critical. So one good example of this actually comes from the freedom of the press, where in many countries, the government becomes one of the primary advertisers, even for formally independent press. What I mean by that is you can imagine an independent newspaper or an independent TV station, where that TV station claims that they're independent, but their primary source of revenue will often be from the government itself that pays for advertising or subsidizes them in various ways. In instances where this happens, where the press is reliant on the government for funding, they become less critical of the government and think twice before criticizing the government on many things. Now, because the government is savvy and recognizes they're going to be criticized less if they fund the government, this all becomes cyclical. The government will fund the press and give them money through advertising dollars. The press will then be less critical of the government, and on we go. And the result is that although groups that receive government funding can push back against the government, and sometimes do, that they're frequently in a position there because of their dependence on the government, they're unwilling to do so. As a result, when possible, truly independent organizations that have outside sources of funding from private philanthropy, from membership dues and fees, can often do a better job of pushing back against the government than groups that are funded by the government itself. All right, I'll stop there on this question.
Okay, so we have a second question from Daniel, I think. He asks, do you think that economic freedom helped these constitutional rights? I ask because some articles on economic freedom report that high levels of economic freedom result in high levels of democracy.
Yeah, good question. So there's, you know, a basic pattern in the data that on average, and this is not perfect, that countries that have higher per capita GDP have higher respect for rights. And that as countries become richer, they are more likely to respect rights over time. Now, there's notable outliers from this. For instance, there's many countries in the Middle East or in the Gulf states, imagine Qatar, Dubai, Abu Dhabi, et cetera, that have high per capita GDP, but low respect for human rights. So we don't see perfect patterns. But on average, there's wealthier people or countries that are wealthier on average respect rights more. Now, why is this? In part, it's because people that are wealthier have more time to engage in advocacy, more time to learn about what their government's doing, and additionally have greater resources to push back. So for instance, if you're a relatively wealthy person and the government's doing something that upsets you, you can drop what you're doing, organize, protest, campaign, et cetera. The consequence is that in instances where there is greater economic freedom that translates to greater economic growth, there's on average greater ability to push back against the government. Now, This is, of course, not perfect, in that there's many countries where there's maybe economic freedom, but governments that retain relatively tight grips over political control, and that they're unwilling to give up political control. So it's not a perfect relationship, but on average, greater economic freedom translates to greater political freedom.
Our third question is from Rafael. Just a second. He says, some constitutional rights are approved by international pressure. And do you think this international pressure could also improve the implementation of these rights?
Yeah, so so the question then here is, assume that a country adopts a right, it could be a constitutional right, or they could sign on to an international treaty. Can international pressure do much to lead the country to actually improve its behavior? This is sometimes called naming and shaming in the human rights literature, or in academia of people that study this. And can these pressure campaigns from international organizations like the United Nations, or Human Rights Watch, or Amnesty International, or foreign governments do something to actually pressure the government? Now, the evidence seems to be that international pressure is less effective than domestic pressure. And there's a few reasons for that. One is that frequently the international pressure might be wide but very thin, which is countries are willing to criticize other governments for their human rights record, but it doesn't mean they're really going to do much about it. So for instance, you can imagine human rights organizations that will criticize the gender rights situation in Pakistan or Afghanistan or Saudi Arabia and say that women's rights are not being respected in these countries. They might have a lot of international organizations that will sign on to the claim that women's rights are not being respected, but then nothing really changes. The government doesn't have to do much because they know they can weather this storm. What seems on average to do more to actually change things is consistent domestic pressure or domestic mobilization. Now, those domestic groups within a country, for instance, women's rights groups or free speech groups or labor unions, frequently what they need is help from international organizations to fund them, to train them, to give them workshops, to give them resources, to give them credibility. But there has to be the domestic movement too in many cases. So you'll have, for instance, domestic women's rights organizations that get help from international groups, but it's this domestic source of pressure. And so although it's possible there can be naming and shaming campaigns that are effective, the more common mechanism to actually improve human rights flows through a domestic channel. That is someone on the ground that has political credibility that is pressuring the government. Otherwise, it's just far too easy for the government to say, some foreigner, some Westerner, some people in Europe or Norway think that we should treat women differently, or children, or gay people, or transsexual people, or whatever differently, but they're not, they don't have our values, they don't understand our country, they don't understand our culture, and they can just be dismissed as foreigners. And so it's really when you've got the domestic pressure that things are more likely to be effective.
Perfect. I think we have time for a few more questions. Anonymous asks, do you think that guaranteeing too many constitutional rights ends up turning judges into public policymakers, even though they do not have the technical capacity to do so?
All right, so let me break that question into two parts. So first part of that was the claim that having too many rights might be part of the problem, that there's too many things in the Constitution. So this is an argument that one of my colleagues at the University of Chicago named Eric Posner has advanced, that he calls the hypertrophy of rights. And what he said is, if you have just one or two core things, it's really easy to say that these are the bright lines that we don't cross. And those might be a prohibition on torture, let's say, or banning opposition political parties, whatever you think these core central things are. But over time, countries have added more and more rights to their constitution, including things like the right to nature, or the right to Wi-Fi in one country's constitution, or a variety of other things. And then judges have to say, look, we can't possibly have everything. We can't fund housing, schools, social security, education, Wi-Fi, protect the environment, et cetera. There's going to be trade-offs. And because of these trade-offs, the way Posner's argument does claim is that we actually do worse on everything, because any individual right seems less important. It seems less like a bright line when we know that there's going to be trade-offs. So his claim is, we actually do better with 10 rights in our Constitution on average than 30 rights in our Constitution on average. We've made a mistake thinking that there aren't trade-offs between these. Now, I don't know if anyone has a really good study to test this exact claim well. That is, does the adding one more right decrease the protection of other rights? This is, for anyone in the room that's looking for a thesis topic, I think a great question that people always talk about, but no one's really nailed down the answer. The second part of the question is how this relates to judges. I'm not sure whether or not this hypertrophy argument interacts with judicial independence. So the thing that Mila and I have focused in our research is pointing out various reasons why judges are often hesitant to enforce rights against the government, regardless of how many they are. For instance, judges are nervous about the budget within their country and know that there's budget trade-offs. So people will bring lawsuits saying, there's a right to education in the Constitution, my children still don't get a good education, you're violating our rights. Or there's right to housing in the Constitution, but I'm still homeless and I live in a slum or a shanty town. Why can't I get public housing? And judges typically find a way to avoid actually giving someone better education or better housing because they don't want to be the one setting the policies. Sometimes they will set the policy and make a judgment, but other times they won't, and they'll just sidestep the issue. But the consequence is that judges often don't do a great job at enforcing constitutional rights. Another famous University of Chicago scholar who's now retired named Jerry Rosenberg wrote in America, the famous book on this called The Hollow Hope, which was to say that we all thought that rights would be this great hope to improve our freedom, but it turned out to be a hollow one. And his claim is because courts aren't able to really do anything. They, as the old saying goes, they control neither the sword nor the purse, and as a consequence, can't translate rights into actual change.
Oh, well, I think we still have a few more minutes. Our question is from Stephanie. She says, basically, as far as I understand, this will be an eternal debate, even considering all the research you showed. However, do we have a light, or will this challenge concerning, the enforcement of constitutional rights be eternal?
So, good question. That's my hope is that this is the kind of subject that we can actually make progress on. And to be clear, the way that scientific progress and social science progress works, it's not a linear journey where with each study we know for sure new facts and those facts never change. I assume that there will be people that do research that find that some of my conclusions are false or wrong and find better evidence. And that's exactly how science goes. But the hope is that although progress is rocky and there's advancements and retreats, that we move towards getting an answer to some of these questions as more people study this. And the thing that I'll say is, as recently as 15 or 20 years ago, no one even tried to answer these questions, which is to say, people would talk about the importance of different rights in purely normative terms. They would say, we should have a right to education because education is important, or we should have the right to healthcare because healthcare is important. But there weren't researchers, lawyers, political scientists, economists that were then trying to figure out whether or not, if you were drafting a constitution, is it worth your time putting the right to education into that constitution? So what I think is that as we have more lawyers and people with legal training doing research and better understanding of the social sciences, that I think that we can at least do better. So even if this isn't the kind of question that we fully perfectly nail down, we can have more knowledge, more insight, better progress towards knowing what makes a constitution effective and when we can actually get constitutional change and what it takes to improve human rights around the world.
Well, I think this is it. Well, we have some questions yet, Adam. It is a good signal that you deliver us a very nice lecture, very didactic, and would like to thank you again. And thank you, Maria Lucia. Would like to give word to Omer as well, and Maria Lucia, if they want to have a few words. Just remind our audience that we have another meeting. The next lecture will be on Thursday, 5 p.m. Rio de Janeiro time and Sao Paulo, and 3 p.m. Chicago time. The lecture will be on the same topic with Professor Tomás Pereira from FGV Direito Rio. I think will be a very good match with the discussions that we have this afternoon with Professor Adam. That was brilliant. And thank you again very much. We are pleasure to have you here in this program. And of course, in future opportunities as well, as we intend to keep this forum running for the next years as well. So please, Omri and Maria Lucia, your last words before we end our meeting. And thank you for the audience for being here with us again. And we see you again next Thursday. Your microphone, Maria Lucia.
Sorry, just to say thank you for all your efforts, Rodrigo, Omri, and thanks so much for your fantastic lecture, Adam. I enjoy a lot. Thank you.
Thanks, everyone. Appreciate it.